in custody. On this, the 15th day of May, payday for most of government employees, we are in the Pinetown F Court with court case number F245 of 2026, the matter of the state versus Fadiel Adams. It appears before Mrs. Robinson. Representing the state is Advocate Kaba and Advocate Ngobo. Representing the accused is Advocate Kangai, duly instructed by DMI attorneys in Devon. There is no need for interpretation. Matter postponed for further hearing of the bail application, with the applicant to submit his arguments on the merits of this application. Let me please the court.
Thank you. Thank you, Mr. King. Mr. Adams, you may be seated.
At the outset, due to the length and the loads of evidence that have been placed before you, I find it necessary to remind Your Worship that we are dealing with the bail application in terms of Schedule 1. Your Worship, much evidence has been led, and I need to deal with certain of the aspects dealt with by my colleague in his address before I address you in respect of the accused personally. In order to be able to do so effectively, I want to place on record a timeline of events as they transpired. And this timeline is going to be important in my argument at the end of the day. The first point that I want to place on record as far as the timeline is concerned is the 30th of April 2026. That is the date on which the J50 warrant was authorized. The next important date in the timeline of my argument of these events is the 2nd of May 2026. The reason why it is important is because on that day at about 4 a.m., individuals purporting to be policemen went to a house where Adams, the accused, had lived previously. That is an important moment in the timeline of the events that we are going to deal with. It must be remembered also, as we deal with the timeline, that the 1st of April was a public holiday.
1st of May.
1st of May was a public holiday. The next important date that I want us to take note of mentally as we go along is the 3rd of May 2026. Many things happened on this day. There were correspondences between the task team and the attorney, Mr. Schroeder, of the accused, regarding him handing himself over or discussions in that regard. And the 3rd of May 2026 is also important insofar as it relates to General Mkwanazi's email to General Gopal. The 4th of May is another important day. The 4th of May is the day in which the accused legal team launched an urgent High Court application to compel disclosure of the warrant. On the 5th of May, Justice Njokweni granted an order for disclosure of the warrant. The accused was arrested on the same day before the court order was complied with. And so, Your Worship, the reason I place this chronology on record so pertinently is because many things have happened in this short space of time that makes it look like a long time had elapsed between the granting of the warrant and the arrest itself. This is particularly important when you consider that my colleague has argued that the accused was trying to prolong or delay his arrest. He first became aware of his arrest or the potential arrest at the soonest I could glean from the evidence before us was on the 3rd of May. And he was arrested on the 5th. It's a space of 2 days. Just 2 days. And a lot of things happened in those 2 days. With this sequence in mind, it shows, the sequence shows the accused's efforts to clarify his eventual arrest, and it also reflects his willingness to engage the legal process. He didn't run away. He didn't move to another country. He was available. His first opportunity to engage the legal process was on Monday the 4th. His attorney was engaged in discussions and exchange of emails and correspondences, and I'll deal with those in a short while, on Sunday the 3rd. His suspicions that he might be arrested were aroused by the fact that on the 2nd of May, and this fact has not been denied, that people wearing balaclavas, policemen wearing balaclavas, visited the house where he had lived previously. All of that evidence is on record. That prompted him to believe, or prompted him to want to know, is my arrest lawful? Do they really have a warrant of arrest to arrest me? Was it properly obtained? Those are his rights to question. He then engages his attorney over the weekend. On the 3rd, there's his engagement between Schroeder and Lieutenant Colonel Majila regarding the potential handing over. There is some dispute between them, as you will see in the affidavit of the investigating officer. And I ask your worship to take full recognition of it's SM1, the correspondence between Lieutenant Colonel Majila and Major General Gopal, and then there's, but it's on the letterhead of Schroeder. And particularly, I ask your worship to take note of the comments that are made by Schroeder regarding the handing over, as was believed by the police that it would be on the 3rd of April at 9 o'clock. And Schroeder was clear about that he did not say that would happen. And his version was also that he had not made contact with his client by then. Now, Your Worship, it is against that background. An accused becomes aware that he is potentially going to be arrested. Policemen wearing balaclavas go to a home where he was. There's an incident. It makes him think that, hang on, of all these things in the media, let me get my attorneys to find out what is going on. And he then makes, through the courts, through his attorneys, a request to say, show me the warrant. If there's a warrant, I'll hand over myself. He doesn't know who these policemen are. Why would policemen go to a place wearing balaclavas? Police are supposed to identify themselves if they're up to a normal police business. It creates the impression that they were up to no good in the mind of Mr. Adams. Why would they not want to disclose their identities? They don't say who they are. It concerned him, and he went then to the courts. He didn't run away. He didn't find a place to hide. He went to the courts. He went to his lawyer and he went to the courts. On Monday the 4th, the first thing he does, his lawyers do, is they lodge an application. The state is aware of it. The PKTT is aware of it. And then on the 5th, there is an order. The PKTT is aware of it, but they arrest him anyway. And he doesn't resist arrest when they find him at the parliamentary precinct, which is his work address for all intents and purposes. I will deal with that issue raised by my colleague about how impermanent or temporary that address is. Your Worship, this is the background. against all of which I will deal with. Now, this is the background up to the 5th of May. My colleague, Mr. Kaba, and before him, Mr. Mata, told this court that they didn't intend to oppose bail in this matter. They were just going to bring the accused here, deal with it, and let him go. But something happened that changed their minds. Something triggered them to say, no, we need to deal with this accused differently. And what we must try and determine is, what was that? What was that incident? What was it that happened on the 6th that changed his mind, the mind of the prosecution? Until then, they didn't believe he should be remanded, he should be kept in custody. Now, Your Worship, when I look at the events as they are contained in the affidavits, it appears to me that what happened on the 6th, or one of the things that happened on the 6th, is that the state obtained a statement from a witness who, as was described to you during Mr. Kaba's address, that the accused was interfering with the witness, or he used that incident as proof that there was every likelihood that the accused would attempt to interfere with witnesses. The other main issue that he raised was the fact that the accused might try to evade trial, and he counted, amongst all other things, the fact that the accused sought to go to the courts to get clarity on the search warrant, as, in his own words, what is that if not an attempt to evade trial? When I speak of Mr. Kaba, I talk about the state's view, but he's the one who presented it. I don't want him to think that I am personally attacking him. Now, Your Worship, I want to refer you to two documents. They are SM6 and SM7. SM7 is the WhatsApp messages. Can you skip me here, SM? And SM6 is the statement that has been blocked out by the witness who was receiving all those calls. Sorry. SM. All right. Your Worship, I'm sure it's the WhatsApp, the screenshots of the WhatsApp and that statement. Now, Your Worship will remember that this is the incident, or this is the incident when Mr. Kaba said, in the others we showed you possibilities, but this one, there is no other inference to be drawn than that there was interference or an attempt to interfere with the witness. This, Your Worship, in my view, was the state's strongest ground to oppose bail. This would have been, in my view, and I would have, if I didn't have to say what I must say now, have conceded that the accused had indeed done himself a disservice by contacting the witness. It is not disputed, and Mr. Kaba pointed out that it was not disputed in Exhibit D, or nothing about this witness was said, or it was not disputed that he didn't know the witness. It can be taken as a fact that Mr. Adams contacted this witness in exactly those times and those circumstances as Mr. Kaba described to you. I'm not going to labor the record. You will recall how the state went through the times and the moments and how late the calls were and how Mr. Adams doesn't sleep and created the impression to you that this was a desperate attempt by Mr. Adams to interfere with what he knew to be a state witness. Now, before I go on, I want to deal with that a little bit. No witness in any matter, in any scenario, belongs to anyone. As much as this witness, and we know who it is based on the statement, we know who has been called, as much as this witness may testify on behalf of the state, this witness was equally potentially a witness for the defense. As I go through the statement, you will appreciate that this witness is the witness that Mr. Adams would have relied upon to demonstrate his innocence as far as those charges of defeating and as far as those charges of fraud are concerned. Now, when do these calls take place? The 3rd of May and the 4th of May and perhaps the 5th of May. Now, I want you to slot that into the timeline that I presented to you earlier. On the 3rd of May, what is Mr. Adams busy doing? Mr. Adams has instructed his attorney to take court action regarding a certain incident, regarding the warrant of arrest. Who is his potential witness? It is this very witness that he could rely on. Mr. Kaba suggested that he ought to have known that this is a state witness. Likewise, the state ought to have known that this could be Mr. Adams' witness. He was there at the prison, engaging with Mr. Adams when he was there. The state does not own this witness. This is a witness that is available to both parties, and both parties can try and secure his evidence for their purpose. So the first thing is, let's dispel the idea that it is a state witness on the 3rd of May. Now we know it is a state witness because the state has demonstrated that they have a statement. When Mr. Adams called him on the 3rd of May, he was just trying to secure the evidence of a witness that he knew could bear out his version. And so he tries desperately, as we've been told a few times. He tries and there's no answer, and then there's an interaction, and it goes on as Mr. Kaba described perfectly. And Mr. Kaba continued with his statement up to the point where he said that he was shocked at the audacity of the accused to give his parliamentary email address to receive the statement from this witness. Now, I actually am going to suggest to you later that that fact that he gave his parliamentary address is proof that he was not trying to run away, he was not trying to conceal his identity, he was open about who he was and where he was. All he wanted was documentation to be sent to him. Mr. Kaba stopped there as far as that witness is concerned. He didn't take it further, and it is a pity that he didn't, because I now wish to read into the record what the witness says, what the state witness says in paragraph 5 and 6 of his affidavit. He says, on Tuesday, the 5th of May, at about 7:57, he sent me a WhatsApp message, and I'm overlapping now with where Mr. Kaba finished off with the phone calls. Morning, sir. I did not respond. And at 8:27, he sent another WhatsApp message, still asking for the statement, indicating the truth must come out. Indicating that the truth must come out. I did not respond. Then at 8:52, another WhatsApp message indicating what needs to be on the statement. I did not respond. That is misleading. I will ask Your Worship. I will deal with it in a short while. Next, in paragraph 6, this is what he says. Due to the frustration and volume of the messages I was receiving from him, I decided to call him at 9:29 via WhatsApp. And I told him I am not going to give him a statement as I have provided this statement to the police and that he must stop calling me. He agreed, and I dropped the call. At 9:51, he sent me a screenshot of SAP's media report requesting him to hand himself over. I responded and told him to please comply soon and hand himself over. He replied at 10:03 and said that he will hand himself over. After the High Court ruling, I did not respond. This is their witness reporting what Mr. Adams said he would do. This is not Mr. Adams saying, I'm going to run away and nobody's going to find me. He said, no, I've got a High Court application. As soon as the ruling, I'm going to hand myself over. When the witness told him, I have made a statement to the police, he stopped asking because he realized now he realizes, okay, this is the state witness. Until then, that witness was available for him to try to consult with, to consolidate his version. And so that is an important thing that we must bear in mind. I was somewhat disappointed that Your Worship was not taken through SM7 fully. You were told about the, that is the screenshots. You were told about the fact there were calls and your attention was drawn to picture as if to say, look, it's me, answer the phone. But if you look at the top of the 7, there's a name there, Fadiel. There was no need for a photograph to be sent to tell him that it's me, answer the call. He knew where these calls were coming from. It was a contact saved on his phone. There was no surprise. It was no secret phone or whatever being used. But that is not of importance to what I want to draw your attention to. What I want to draw your attention to is on the 3rd page. It's got a voice call at 3 minutes on the top, a missed voice call, and then the first message on the 3rd page that says, Chief, can you please send me a statement confirming what actually happened? And that is the point at which he gives his parliamentary email address for him to send it to. The next line, Mr. Kaba, the witness in his statement says he said, morning, sir. But none of it is quoted in the statement, and none of it is brought to your attention. And I want to bring to your attention what the accused said and the message that the accused sent to this witness. He says to the witness, I need that statement, please. It is important that the truth come out. From the first moment we met until we parted ways, only the whole truth. I am not asking for favors. Does this sound like someone who's interfering with the witness or someone who's trying to see to it that the truth emerges of what happened at the prison? Mere contact with the witness does not amount to interference. As I said earlier, Your Worship, nobody owns a witness. Witnesses make statements in the police docket, and then they come to court and they tell a different story. Witnesses make statements in the police docket and then go to lawyers and say, but we were forced to make this. Any of those things is possible. And so it is not the only reasonable inference that this witness was being interfered with. In fact, the totality of the evidence, which was not brought to your attention, suggests otherwise. The totality of the evidence suggests that Mr. Adams was seeking for the truth to come out. From the first moment we met until we parted ways, he is deliberate. He says, I need no favors. And the state wants you to believe that Mr. Adams has the potential to interfere with state witnesses based on his contact, not on his interference. He's not telling the witness, say this, don't disclose that. He's not saying, lie about this or that or the other. He says, tell the truth. Write your statement. When he's told that the police have already taken the statement from me, he stops calling. I don't see the interference as was suggested. And interference with this witness, Your Worship, is not the inference that can be drawn from the conduct of Mr. Adams. Mr. Adams was a man in the middle of litigation. It is not unusual for someone who's in the middle of litigation to start to bolster his version by securing statements from people who can potentially confirm that what he says is true. Your Worship, if Mr. Kaba and Mr. Mata were honest with you that something happened on the morning of the 6th that changed their mind, then this is the only thing that the docket show happened on the morning of the 6th. Until then, they were quite happy to bring Mr. Adams here and release him on bail. That's what they tell you. They could have achieved that simply by issuing a summons, which would have been the least intrusive method of getting him here. But they chose to get a warrant of arrest. They chose to do so, quite coincidentally, it happens, on the last day before a long weekend. Now, Your Worship, the fact that there was a long weekend in between the obtaining of the warrant of arrest and the actual arrest on the 5th makes it a space of 2 days, actually, because remember, Mr. Adams had decided he's not sure about what is going on. Policemen with balaclavas are going to properties that he owned previously. He doesn't even know if these people that are coming to deal or talk to him or for whatever purpose they come are even legitimate or even have proper grounds, and he wanted to satisfy himself. That is his right. He didn't just run away and duck and hide. He got his lawyers to engage with the political killings task team. And remember, Your Worship, this is a political killings task team. I can only wonder why such an elite team is chasing after and seeking to arrest with all of their might over a long weekend a man who is charged of defeating the ends of justice. Now, Your Worship, as far as the interference of witnesses and the likelihood, I submit that the state may well have a suspicion, but the evidence does not demonstrate that there are any grounds, or to put it differently, the grounds that are submitted by them that you should take into consideration to come to the conclusion that there is a likelihood that the accused will attempt to interfere with witnesses is non-existent. It is very much like Mr. Kaba said, self-made. It's a self-made belief that there will be interference. There is no evidence to demonstrate that. Your Worship, the next thing that I want to deal with that I was a bit surprised that it was even mentioned was regarding his proof of residence. Now, if it ever becomes necessary and acceptable in terms of a bail application, that in order for a court to be satisfied of proof of residence is that your name must appear on a title deed, 90%, if not more, of this country will have not a hope in hell if they faced before a bail court. Mr. Adams, the state, the investigators did an inquiry. They found out that Mr. Adams did own houses. They went to those houses. They did not go to the house where his wife was because his name was not in the title deed. They don't feel comfortable that he has given you proof of residence because his wife's name is on the title deed. He was married to her, he divorced her, and they remarried. They don't think that that is sufficient proof that he has a fixed address. Your Worship, I shudder to think what the position would be for tenants who occupy premises. You have before you a sworn affidavit, proof of address with an affidavit from the wife saying that this is my husband, this is my house, and he lives with me here permanently. The state highlighted his marital history, but the question is not about the permanence of his marital status. The fact remains that he is in a committed relationship with his family unit within this country, and he's provided you with a perfect permanent address. And he says, for the purposes of work, I also consider to be my permanent address currently the parliamentary residence in Cape Town. If I'm not at home, you'll find me there. It's true, if his party withdraws his candidacy for Parliament, he will have to leave that residence. But that is why we have that condition which we normally put in bail applications or in bail, where we say, if you change your address, you must inform the investigating officer. That is why that condition exists, because it anticipates that people won't live forever in that one spot where we arrested them, that they might move, and if they do, they must provide the investigating officer with an arrest. So the state's uneasiness about the fact that it is a parliamentary residence and it doesn't belong to him and he can leave it and go away at any time, or the privilege can be withdrawn, Your Worship, it does not, in my view, satisfy a concern for the fact that he does not have fixed property in his own name. Mr. Adams has demonstrated that his family is dependent on him financially. The house may be in his wife's name, but they are dependent on him financially. His children are dependent on him financially. They all live at that address that he has provided, and it is the address that the state has put on the charge sheet. The state, from the time it got the warrant, the police, from the time they got the warrant on the 30th, went to houses they knew that he owned, and then felt that no, he's got far too many addresses and it's going to be difficult to find him, so we are going to make that into an issue. But the fact of the matter is, like most other people who live in one town and work in another, he has a residential address and he has a permanent work address while he is working in that place. And so therefore, on that issue, which was relied upon as a ground upon which he might, or as proof that he might try to evade the justice, is a non-existent ground and is only, again, a suspicion by the state. In that category, the statement of General Mkhwanazi, the email of General Mkhwanazi, played an important role, and it was used to try to demonstrate to you that Mr. Adams might well try to evade trial. And it was used even to demonstrate to you, together with his court action, and it was asked, and you were asked the question, is that not an attempt to evade trial? How can somebody exercising his constitutionally protected right be an attempt to evade trial in the circumstances of a bail application? It makes no sense, Your Worship. But I want to deal with that aspect that my colleague relied upon to say that this confusion was self-made. Again, I ask you to refer to the timeline that I described to you at the outset, and to slot what is happening and to place yourself in the position of the accused as to when and what this email conveyed to him. It doesn't matter what we now can establish and where we can go and refer to other letters and get other people's opinion. Is what impression did this email make upon the accused in the timeline as I've described it, and in that moment in time when he got it for the first time or heard of it for the first time. I have no idea how the accused interacted with it, but he has knowledge of it. This email was sent on Sunday, May 3rd, 2026 at 8 a.m. Now, if you slot that into our timeline, it is just one day after policemen or people disguised, let's call them people disguised because we don't want to blame anyone, but we know for a fact that that fact has not been denied, nor has the PKTT said, as far as I am aware, and if they did, I apologize, nor have they said it was not us. He is outspoken about it, he makes videos about it, and he says, balaclavaed men came to a house where I lived, hit a 12-year-old boy, interfered with the people there, and went. That was on the 2nd. On the morning of the 3rd, now he gets worried. He calls his lawyer and he says, listen, man, I don't know if they're trying to arrest me. Can you please find out if it's legitimate what is going on? Or maybe it's just somebody trying to do something or harm me in some way, whatever. He's concerned, so he starts to take action. On the morning of the 3rd, he gets an email or either the email or he hears of the content of an email that reads as follows. I heard that you are looking for Mr. Adams and thought that I must share this letter which was emailed to the acting minister of police, and a copy was sent to me in April 2026. There's no date in April. It doesn't say the 9th of April. It doesn't say any of those things. It says it was sent to me in April. It could have been the 30th of April. The message it conveys is that it came in April. But that is not of importance to the accused. He is concerned. What is he concerned about? He doesn't care when somebody received an email and what they did with it and how long they sat on it and whether they acted on it immediately or why they didn't act on it immediately. What he cares about is the message that it conveys. And what he says and what he hears from this message is, in receiving this email, I made inquiries with the prosecutor who is handling the case, and he informed me that there was no warrant. It goes on to say, as you know, I've been out at Johannesburg, and I'm not fully aware of what's going on in KwaZulu-Natal, and whether the applicant has stable ties in the jurisdiction. He goes on, sorry, where is the second page of this? FA4. Joshua, I cannot find the second page, but I believe that you will have it. Anyway, what happens is, and it's quoted on paragraph 9.1, I think, of the applicant's affidavit, where it goes on to say, the message that it portrays at the end, of which is of interest to the accused, because remember, he's the one in the middle of this whole thing. Unknown people are visiting houses where he lived. He thinks that people are coming to arrest him. And now he gets a message that says, I did ask the prosecutor. He said that there was nothing. However, I found out that a warrant of arrest has been issued. What impact would that have on a normal human being who is anxious about the fact that he might be arrested by people he doesn't even know where they'll take him? He says, I want clarity on this thing. It is not a self-made confusion. The confusion comes from the way this letter is worded. The letter is not clear. It doesn't say, I asked the prosecutor 3 weeks ago, he said no. But it would seem to me that 3 weeks later, it doesn't say that. What the message conveys, perhaps it didn't intend to convey that, but what it conveys is that I asked the prosecutor, he didn't know, but I have now found out that there is a warrant of arrest. His confusion is not self-made. His confusion comes, and his concern and his anxiousness comes from the circumstances that are surrounding him and what is unfolding around him. Any normal human being, even if he was mistaken to think or interpret the letter incorrectly, any normal human being could make that mistake. And what does he do? Does he run away? Does he jump into a plane and go away, far away from South Africa? No. He runs to his lawyer and he says, get me an opinion. I want you to look at the warrant, see if it is order, see that this is not somebody just abusing the process of law. That's what he does. He wants clarity. And you are told to believe that those factors constitute an attempt to evade justice. This is normal human behavior. Now we have before you an accused who there is no evidence that he tried to interfere with any witness. In fact, if anything, he said to the witness, tell the truth. Say what happened. I want what happened when from the time I arrived to the time I left to be placed on record. Then he takes legal action. He says to this person, as soon as the court case is over and I've seen the warrant and I'm satisfied, I'll hand myself in. He doesn't go and hide somewhere in another town. He goes and hides in the most obvious place you would find him if he was not at home. He goes to the parliamentary residence where he works. My colleague seems to suggest to you, and I will again say it is his suspicion, that the accused labored under some misconception that if he was on the parliamentary precinct, he could not be arrested. Which would mean that the accused believed that if he stood in the parliamentary precinct, he would have to stay there forever because the moment he stepped out, he could be arrested. It is a suspicion that the accused, that the state has, but it is not a fact. He was at the parliamentary precinct because that is his alternative address when he's working. That's where he was. And so I ask you not to be, it all sounds well when it's presented as theatrically as it was, but it is not a fact. And again, I remind you, Your Worship, that this bail application is a bail application in terms of Schedule 1. Your Worship, I submit then that the fear that the state has that the accused will evade his trial. He has said over and over again, I'll hand myself over. He goes to court and he says to the court, if they hand it to my lawyers and my lawyers look at the warrant and they are satisfied that it is all in order, I will hand myself over. He tells the witness that he's supposed to be interfering with. As soon as the court makes a decision, I'll hand myself over. As soon as the court, what the court requires is done, I'll hand myself over. They find him at the parliamentary precinct. I have not watched that video, or if it was shown, I missed it. But I am told that Mr. Mashele had to grab him. Your Worship, there is no witness. What did he try to do? Did he try to run away? Did he hide somewhere in a bush? Did he lock himself in the house? No, he just stood there, he spoke to them. If Mr. Mashele had to say to him, come, let's go now, by grabbing hold of his hand, that's fine. There's no evidence that he tried to run away. He's standing there talking to the policeman, many policemen. And the state wants you to believe that Mr. Mashele, because he had to hold him or grab his hand or whatever, that you must treat that as an attempt to evade trial. Your Worship, that ground that my colleague relies upon simply cannot stand. Not on the evidence that is before you. And even if your mind is not clear on all of these issues that I've raised, that is the reason why bail conditions exist. We can control his behavior using bail conditions if he's released on bail. I have dealt with the issue of interference with the witness. And I want you to take notice, Your Worship, that there is no explicit instruction and there is no explicit suggestion by the witness in his statement that there is an instruction to change your statement, withdraw your statement, don't cooperate with the police, protect me, say this instead of that. Most importantly, what it actually says is, I am not looking for favors. And the state ignored that part of that entire conversation. And I submit with respect, it is because it did not suit their narrative that this is a flight risk. When it was suggested to you that the only influence is interference, I submit that it was an overstatement, because there are at least two plausible inferences. There is the state inference that he was attempting to interfere, and there is now before you, I submit respectfully, there is the defense inference that you can draw, and that he was attempting, perhaps he was clumsy about how he did it, and perhaps he did it improperly, to understand or to obtain a witness's version of what had occurred. That distinction is crucial. This is a bail application. This is not a final adjudication. There are two plausible inferences. The other important thing, Your Worship, to remember is that the witness repeatedly refused engagement. He ignored calls. He did not provide the statement. And he maintained his cooperation with the police. So much so that after the accused was arrested on the 5th, on the morning of the 6th, he wrote a statement, perhaps with the view that it would be used in the bail application. But the witness's cooperation with the state had not been interfered with at all. There was no attempt to do so. And the suspicion in the state's mind regarding interference is a non-starter. You must also bear in mind, Your Worship, there are no threats against the witness. There's no menace. There's no coercion, no inducement, no bribery, no pressure. The tone of the communication between the accused and the witness, he was persistent, of course. It was inappropriate, I will agree. He was anxious. Perhaps he was reckless, but he was not threatening at all. In that circumstance, I submit again that it is a suspicion by the state that he was interfering. Now, I said to you that I would address the issue of the parliamentary address, which my colleague described as he had the audacity to give it to the witness, to send him the statement. Well, it might be audacious if you want to interpret it that way. But if you look at it objectively, it also suggests a lack of concealment. A person who is consciously orchestrating a covert obstruction of evidence usually does not use traceable official details. does not identify himself openly, does not repeatedly identify himself on WhatsApp video. The accused was not hiding anything. He was quite open about what he was doing, because all he was trying to do was exercise his rights. Even more important, Your Worship, even more important, the accused was arrested on the 5th. Today is the 15th. It's been 10 days since he's arrested. He by now knows the charges against him in more detail. He knows who the witnesses are. And there is not a stitch of evidence before you that after his arrest there was any interference whatsoever from anyone. If there was, we would know about it, because the witness has demonstrated his loyalty as a state witness. Your Worship, to summarize that whole issue of interference, which was the state's, in my view, strongest point in order to oppose bail, the messages to a state witness or to a witness unquestionably justify concern. He should have not done that. He's been informed not to do that now. But we have to look at what he did. And we have to look at what he did and say, is this so bad? Is this interference with the witness? And the answer to that question is no. Your Worship, there were other points that were raised by my colleague in support of his contention that the accused will interfere or evade trial or interfere, which were his two strongest points. And I submit that none of those strengthen his case after the main points upon which he relies have been clarified as I have done now. And there must surely be those two pillars upon which he based his argument must now surely fall. Now we go to that third one that seems to have caught the attention of everyone. And I want to be the first to place it on record that my client does not use the most beautiful language when he speaks. My client is quite a loud person. My client is quite an outspoken person. My client says what he thinks and is afraid of no one. But Your Worship, nowhere in the Criminal Procedure Act section 60(4) do I find that those are conditions or elements for which you must refuse bail. I will deal with that when I address you in conclusion, as I am going to do in a short while. Your Worship, it was suggested to you that my client has had previous brushes with the law, but as he stands before you here today, he has no previous convictions. In its desperation, the state presented to you what amounts to records of a certain incident and argues and says that the NPA had to intervene and mediate for the matter to be resolved. I'm informed by my client that the intervention by the NPA meant that he went there. There was a Mr. Riley who represented Cape Town municipality, who was the legal representative. He produced his receipt to show that he had been for the course that he had been ordered to, but he was unable to produce the certificate because even till today he has not received it. And then the matter was dealt with. There was no mediation, as it were, And I'm relying entirely upon my client's version of those events, and the state has not provided anything further than that. The mere fact, Your Worship, is what he has to do in terms of the law is tell you whether he has previous convictions or not of any sort. And he's put it to you, and the state has not proven anything different, that he has no previous convictions, that he has no pending cases. And to suggest that this case is one in which suggests that the accused can resort to violence or is of a violent nature, or he threatened people and he continues to call people out and speak badly about two people, that may be true, Your Worship. I cannot dispute that. I heard the videos together with Your Worship. But that is not, those are not elements. And if we start to deal with bail applications in terms of a person's personality, and if we start to deal with whether a person should be granted bail because he has bravado and he's flamboyant and he uses foul language, Your Worship, then bail applications will not be an exercise of a person's constitutional right. People have bad personalities. It's too bad. Did he violate anything, or did he act in any way that suggests to you that he should not be released on bail? Your Worship, I have dealt now with the submissions made by my colleague. Now I'm just going to address you particularly in the light of all the evidence of why I submit that the accused ought to be released on bail in these proceedings. And I once again place on record that this is a bail application in terms of Schedule 1. In my address to you, I rely on the principles of our superior courts, and I'm not going to say the whole citations of the cases because I'm sure that they're well known to you. But I do have them if it is needed. State versus Dlamini, Dladla, Hubert, and Shitakat. State Matubula versus the state. State versus Bota and Anand. State versus Porton, and State versus Mabina and another. Your Worship, those are the classical or the locus classicus when it comes to bail application. And I will deal a bit with their applicability in these proceedings and sum up my address to you. I'm not intending to burden you with repetitive citations. Those are the cases I will rely on. The applicant appears before you, and he is presumed to be innocent. And the inquiry remains whether the interests of justice require his continued pending trial. And that onus rests with the state. At its core, the matter concerns one central question: whether the objective evidence before the court demonstrates an accused who can safely and reliably stand trial under appropriate bail conditions. I submit with respect that the evidence overwhelmingly demonstrates that he can. Your Worship, much of the state's opposition has focused not on concrete acts of absconding or violence or intimidation or destruction of evidence, but rather on the applicant's personality, his public language, his political temperament, and his social media conduct. The state has demonstrated that the applicant is an outspoken person. It has demonstrated that he is politically combative. The state has demonstrated that at times he uses language which is coarse and provocative and deserving of criticism. Those matters may legitimately attract disapproval, but criticism of personality, as I said earlier, is not the statutory test under Section 60(4) of Act 51 of 1977. The inquiry before you, Your Worship, is not whether the applicant is a polished, diplomatic, restrained, and universally likable person. The inquiry is whether the state has established a likelihood that the applicant, if released, will evade trial, interfere with witnesses, undermine the administration of justice, or otherwise render the criminal justice process unmanageable. That is the inquiry. The distinction is critical. If political bravado and vulgarity, criticism of institutions, and flamboyant public conduct become sufficient grounds for detention, then bail ceases to be a structured constitutional inquiry and becomes an assessment of personal approval. That is not our law. In State v. Lamini, which I cited, the Constitutional Court made it clear that the inquiry remains whether the interests of justice permit the release through objectively identifiable statutory risks. In State v. Porton, the court warned against detention rooted in emotion, atmosphere, or public pressure, rather than objectively demonstrable risk. Your Worship, the state repeatedly characterized the applicant as a fugitive. A reference was made in this regard to the Harrison Ford movie, and I couldn't help but ask the accused, what was that reference about? And Your Worship, these were his exact words to me. He first asked me if I watched the movie, and I said no, and he said he suggests that everyone should. Because in that movie, Harrison Ford was a fugitive from a rogue police unit, which is what he feels he is as well. He was not trying to say that he's as good or bad as Harrison Ford. He was trying to say that it was a rogue police unit that was pursuing him. But the rhetoric must be separated from conduct. The state relies heavily on public statements, social media, video, and the applicant's comparison of himself to Harrison Ford in the film Fugitive. Even if we accept the state's criticism of the language, the theatrics employed by the applicant, the court must still examine what the applicant actually did. I place on record the following. Objectively, he did not flee the Republic of South Africa. He did not disappear. He did not go underground. He did not use false identities. And he did not sever communication. And he did not conceal his whereabouts. On the contrary, he remained publicly visible. He continued appearing publicly. His legal representative communicated openly with the authorities, and he was ultimately arrested openly at his parliamentary residence. These are not the hallmarks of a genuine fugitive. A true fugitive disappears from public life. The state correctly points out in section 64B that it does not require actual evasion, but also the likelihood that the accused will attempt to evade. That is correct. But attempt requires conduct genuinely directed towards evasion, and there was none from the accused. The state's own evidence demonstrates continued traceability and public visibility. The applicant has no previous convictions, no prior history of absconding, no history of breaching bail conditions, and no evidence exists of any prior failure to attend court. In previous, when he was charged, on each occasion, he attended court till the finalization of those matters. He has never traveled outside the Republic of South Africa. He has a passport and he's offered to surrender that to the state. I have dealt already with the issue of the proof of residence. The issue here is traceability, not the fact that he owns fixed property or not. The applicant is plainly traceable. He is a sitting member of parliament. He is publicly visible. He is politically accountable. He is institutionally known and deeply rooted within the Republic of South Africa. The objective evidence simply does not establish a realistic flight profile. Considerable time was devoted to what the state described as self-made confusion surrounding the warrant in the High Court application. I have dealt with that, and I believe that his confusion, if nobody else was confused, his confusion stems from the way the letter was worded and from the circumstances in which he found himself in those 3 days. The applicant did not evade the courts. In fact, he has demonstrated.
Sorry, Mr. Genga, there's a cell phone ringing and it interferes with my records. I would really appreciate it if cell phones being used by the media could be placed on flight mode and other persons in the court, if they can switch off their cell phones. The record gets affected. I have to reconstruct a record, which is not ideal. So please, if all cell phones could be switched off.
Your Worship,
Yes.
sorry, I apologize.
Sorry, you may continue.
Thank you, Your Worship. Your Worship, the accused did not run away from the courts. In fact, he approached the courts. He went to court for a solution. He trusts the courts. Even for this one, he has indicated that he will attend his trial. He intends to plead not guilty to all of the charges. The state has relied heavily upon the vulgar comments made, and I've dealt with that in some detail. They do not and are not factors, whilst they don't make him a very likable person. They are not factors that need to be considered when you start to consider whether he will evade trial, interfere with witnesses, and the like. There is no contempt conviction before this court. No conviction arising from the events, no history of absconding, and no history of bail violations. What I'm referring to, Your Worship, is those court proceedings in which the accused made what I believe to be very offensive comments towards the court. I myself was even offended being an officer of this court. But as I worked through the evidence, I realized my opinion of what the accused and the foul words that come out of an accused's mouth don't matter towards his innocence and don't matter towards his right to liberty. The state's own evidence establishes the following regarding the witness. The state's own evidence, the statement they provide regarding interference with witness, that there is no threat, no intimidation, no coercion, no bribery, no instruction to fabricate evidence, no destruction of evidence, and no successful manipulation of any statement. The applicant in his affidavit has submitted and tendered strict non-contact conditions. He says so himself that will comply by this. There should be no direct or indirect communication with witnesses, no engagement with correctional officials connected to the matter, no inmate conduct, and he was going to surrender his passport, and he will comply with any condition imposed by this court. Your Worship, in these circumstances, it is my submission that the accused has demonstrated that he is a reliable person when it comes to being trustworthy as far as not evading his trial, not interfering with witness, and not bringing the system of justice into disrepute. Accordingly, I submit that he ought to be released in bail. With regard to the issues raised by my colleague, which went to the merits about his going to the prison and taking pictures and lying to people about what, those are matters for the trial. They not really have any bearing here. If one had to start to deal with that, one can be critical of the charge sheet, but I will leave that for another day. The danger of overextending a bail inquiry into the merits adjudication was recognized in that Constitutional Court matter of State v. Lamini, Dadla, and others. The court is not conducting a criminal trial today. It is dealing with the bail application. I conclude by saying to you that it has been demonstrated to you that the accused is traceable, that he is cooperative, that he is publicly accountable, that he is non-violent, and that he has no convictions, no history of absconding, and that he will not abuse the bail conditions, and that he ought to be released on bail as he requests to be. Your Worship, those are my submissions, unless you wish to hear me on anything in particular.
Thank you, Mr. Genro.
As the court pleases, Your Worship.
Mr. Kaba?
I will just check. Can I just check with the accused in case? As the court pleases, Your Worship, I've dealt with all the issues.
Thank you. Mr. Kaba?
I'm going to have two proposals and requests to the court. It's in fact, it's requests. One, there's my colleagues were making notes. I don't know. I want to just confirm if what I've written is the same thing in our reply. That will end up at 5 minutes or 10. That is the first request, Your Worship. The second request is even after that 10 minutes, we're not going to be longer than 15, 20 minutes perhaps. So can we, if we start at, let's say it's now 20 to 12, 20 to 1, if we come back at 10 to, we just sit through the first half of lunch. If there's no other matter on the road, so that we are changing. That's the second request. I'm
So
also,
it's not going to be longer then?
may I confirm?
No, please keep quiet.
I will keep it. It's just a response to what you're saying. I'll keep it short.
How long is your response? How long do you anticipate it to be?
Not more than 30 minutes. Not more than 30 minutes.
30
honestly.
minutes? Mr.
Even
Kaba?
less. Even less.
Mr. Genga wasn't even 30 minutes.
He was longer than that. But Your Worship, just that is the request.
Please, Mr. Kaba. I still have other matters as well, so please.
I will be short, Your Worship.
For purposes of the record, I am returning your stick. I've had sight. Thank you. Please keep it in your possession. It is not in my possession. I possess no evidence. Thank you. Right, so as you say, that clock is a bit slow. So 10 to 1, 5 to 1.
5
Five
to, yes,
to.
5 to 1.
Thank you.
All right.
Thank you, Worship. May I recall case number F245 of 2026. We wish to... Oh, the accused is not here. My apologies.
Thank you. Thank you, Mr. Gao.
Thank you, Worship. And we wish to first thank the court for the indulgence. It appears today that the timelines might play a big role in your decision as to how to understand how the events went on. On the 2nd of May, police arrived at a residence that the police knew was in the name of Mr. Adams. And as the investigative officer has indicated, they did a profile and picked up which houses. Then they left, they couldn't find. On the video footage of the very same day, the 2nd of May, the applicant himself tells the nation and everybody, the PKTT was at my house. He knew the identity of the police officers who were in his house. No one else says that except him telling the nation. Mr. Kangai cannot stand up now and say, my client did not know who was in my first house. He can't say that. That could not be his instructions. Because his clients knew who those people were. Not only does he say it's PKTT, he gives names to those people, they are criminals and all of that. It explains his explanation to Mr. Kangai in comparison with the fugitive movie. Because he considers the PKTT a rogue unit. So he was doing what? He was doing as Harrison Ford did. I'm running away from the rogue unit. Now, what is it all about the constitutional right to understand the warrant or I didn't know who was in my house? It doesn't hold water. We submit. It doesn't, because he himself knew who was there. The letter or the email FA4, which it is submitted, caused more confusion to Mr. Adams, we are informed, was only sent on the 3rd of May, the following day. How can you be confused if he knew already? And it's a fact, Your Worship. It's not a hidden thing. It's a fact. It is indeed the members of the PKT who went to arrest him. Now, where does this issue goes to? It will come as a fact that the court must consider why the witness was approached. Because we're informed today that in order to bolster his application in court, in the High Court, he needed to have a statement from this witness. Because he did not know who are the people who came to arrest him in his house. Strange enough, if he approached this witness not knowing who are the people who arrested him, why pick him? Why pick this specific witness about this specific incident? I'll tell Lordship why. The letter, the Annexure SM email 1, the letter that is written by his attorney, Mr. Schroeder, will inform the court that on the 3rd of May, it is when Lieutenant Colonel Majila started to negotiate with the lawyer to ask Mr. Adams to hand himself over. Mr. Adams did not go to Mr. Schroeder, as it is submitted by my learned friend. Did not. It's Mr. Schroeder was looking for him and couldn't find him on several times until he did. That's only then that they discussed the matter. Can you hand yourself over? So to say to the court, no, look at him. He was exercising his rights. He was running away, Your Worship, from the rogue unit. He considers to be a rogue unit, not me, him. And Mr. Schroeder says on paragraph 6, on page 3 of that letter, perhaps let's go to paragraph 5. Our client, Mr. Adams, harbors the most serious reservations concerning the legitimacy, alternatively the regularity of the warrant. More particularly, as you had intimated to me, that our client will be charged with fraud and defeating the ends of justice. Colonel Machila has informed the lawyer what are the charges when he spoke to Mr. Schroeder. Mr. Schroeder had then to tell his client what is it all about. Then he picked up, oh, they are here for that case of Westville. Now, what does the witness say on paragraph 4, last paragraph? Then at 2100 hours 30, he sent me a WhatsApp message asking me to send him my statement I made to the police. He's aware now what the police are looking him for. The lawyer goes on to say, and this is not about the case, it's about the legitimacy of the warrant. Why would you want the witness to give a statement about the warrant? The legitimacy or not of the warrant. You wanted to see what is in the statement. Is that not interference? Send me what the statement you made to the police. He is a member of parliament. They prescribe the laws to us. When a person has went to a police station and made a statement, that person is classified as what? He cannot tell the court that he didn't know. I find it strange that my learned friend would say no one owns a witness, when it's clear how this one is categorized. How is clear as to what Mr. Adams asked of this witness. The statement you made to the police. And it's my respectful submission. There's no bearing on the warrant. The lawyer says, should you fail to provide us with a copy of the warrant, and even in the event that you do send a copy of the warrant to us as requested, then should it appear to our client to be the case that the warrant is either irregular, invalid, or lacking in legitimacy, but it instead is a manifestation of a politically motivated arrest amounting to corrupt conduct such as that preoccupies the Madlanga Commission of Inquiry, we shall move an urgent application in the Western Cape High Court to stay the warrant pending. Yeah, I'm being persecuted politically. That's what is in his mind. Now, where is the confusion? The email is sent on the 3rd of May talking about an inquiry and a letter to the prosecutor, a letter that the General Mkhwana has received, an inquiry that he made in April 2026. The email is the 3rd of May. There's no confusion to that. Now, we are informed there's no evidence demonstrating interference. I beg to differ. There is. And it's crucial, Your Worship, I submit, that on the video clips that we played, he indicated with no uncertain terms that I went to the prison to obtain a statement from a hitman, he mentions the name, and I'm being persecuted for that. And he took a policeman with there. So he knew the charges. He knew what this policeman is going to do, or was going to say, and that he is a witness. I'll come to the issue of the title deed. Therefore, to surmise the submission, Your Worship, about the rights, why he went to the court and he conducted the witness, does not hold water, according to our submission. Because we are informed it was in the process of trying to understand who are these individuals, which he already knew. Hence, in our submission, like we said, he was just delaying the process. And what is also clear, Your Worship, is that at times he will switch off his phone so that it could not be traced. And then when he gets to the parliamentary precinct, then he said it himself. It's not us. He said it himself on the video that these people did not have a right to come in. So in his mind, the rogue unit don't have any right to step into the precinct to arrest him. That is an attempt we have proved. Now, you should be informed that no, some of these issues, for example, the address, people change address and then you can issue an order or a condition of bail to say you must inform this, you must do this, you must adhere to these conditions. In the process, we are informed he's not the best of people who use language that is supposed to be used out there. I beg to differ. Let us get to the issue, for example. A judge sitting in the Equality Court issues a court order and specific instructions as to how the applicant must go about in complying with that order. The words were used. One of them is, I am not going to apologize. Indeed, he did not apologize. He did not comply with the court order. Hence, the complainant went to open a criminal charge because he failed to comply. Now, my learned friend wants you to trust this applicant to say, whatever you say, you can give bail conditions that he will comply with. After having said, I'm not going to do it, Not only did he do that, he gave a middle finger to the courts. You are a court, Your Worship. You are entitled to give orders. He has shown you that he doesn't recognize the judge's orders. For him to comply, he had to be dragged to court by the complainant. Now, this is the person that we say, well, trust him. He will comply with whatever bail condition you give. We have not shown that. There's no attempt on that one. There was actually disobedience to a judge's order. Now, we don't have to take the words he said on face value. He acted on them. He acted on them. Your Worship, one might look out there and say, you know, Section 60, subsection 4 applies to Scale 1 offenses. No, that's not the law. Section 6, subsection 4 applies to every offense that is there, including murder. You should not look at it lightly because it's not a Schedule 6 offense and say Section 6, subsection 4 does not apply. It does. It's just that on Schedule 5 and 6, it becomes a second leg thereof, but it is applicable. Therefore, we have to consider and understand what the courts, or rather what the legislature is expecting of the courts in bail applications. Therefore, if there's evidence establishing the likelihood of any of the 5, bail should be refused. That's what the law says. Doesn't matter what the schedule is. In closing, I wish the court to look at the charges that the accused is charged with and listen to his video clips that we played, where he admits having committed this. In his mind, he was allowed, authorized to do so. The extent of what he did in our criminal justice system. I'm not now saying there are allegations that he did it. There is evidence from him that he did it. It's defeating the administration of justice. He is now saying, grant me bail, I will adhere to whatever condition you give in the administration of justice, being charged and confirming on the video footage that I've distracted the administration of justice. Though I think I am, what's the word, correct word I'm looking for? I'm authorized to do so, or I'm supposed to do so. That's his interpretation. But he's done it. Your Worship, that's the bottom line. Therefore, what other evidence is there than what is before you? And lastly, it started by saying the attitude of the state was somehow different to what is happening now. And the state is still to say or still to indicate what changed. And my learned friend pinpointed it to a date. This state was open to the court. and did not specify one incident, and said it is the conduct of the accused that made the state to change its attitude. The conduct also means, what did he do in 2023 or 2024 when he disobeyed court orders? It's not confined to the 3 years, to the three days that Mr. Kangai wants this court to believe. There's a conduct that we realize, something is not right. Your worship will believe, unless there's anything else that the court wants me to address him on, that we have established the likelihoods in terms of section 460 of the Criminal Procedure Act. The only aspect we did not argue on is 4E. The court can, of course, consider whatever is before this court to consider that aspect. Unless there's anything else, Your Worship, those will be my submissions.
Good, thank you. Can we resume by 1:45? I think that should give you sufficient time to get something to drink and eat quickly, and then 1:45.
1:45 is
And I will
suitable.
Suitable, Your Worship.
deal with the ruling. Thank you, Mr. Adams. We'll come back at 1:45 so that you can have something to eat. Right, thanks. Let's stand by.
All right. No,
I see you're supposed to come 2 minutes later.
no, I told you it was.
No, I'm joking.
State resource, eh?
I'm joking.
They don't give us batteries.
Is it 250? Your Worship, I record case number F245 of 2026. State vs. Fadiel Adams.
Thank you, Mr. Adams. You may be seated. Right. Unlike the state and the defense, I have not had as much time available to me to deal with the ruling. However, I will deal with it, as I do believe that bail proceedings are urgent and must be dealt with as speedily as possible. So in light of that, the purpose of bail. The procedural device known as bail attempts to strike a balance between the competing criminal justice interests. Bail is an attempt to ensure that the accused presents himself at his trial, while at the same time giving due regard to the principles and policy considerations that underlie the criminal justice system. The granting of bail in nature is a contract in terms of which the state commits itself to the accused continued interim freedom once the court has authorized his release, while the accused commits himself to standing trial. It is apparent that the contracting parties are the state and the accused, and although the discretion to grant bail vests with the court, in exercising its discretion, the court must seek to strike a balance between protecting the liberty of the individual and safeguarding the proper administration of justice. The purpose of any bail system should be to promote and protect the interests of society as well as the interests of the individual. This bail application is a Schedule 1 bail application, as I have been so reminded by the defense on numerous occasions. The state has opposed the release of Mr. Adams, and in deciding whether or not Mr. Adams is a suitable candidate to be released on bail, the court must consider what is in the interests of justice. In terms of South African law, which is I am a presiding officer which is bound by the rules of court, and I must follow those rules. The concept of the interest of justice is refined in Section 60 sub 4 of the Criminal Procedure Act, which provides that an accused person if he or she were released on bail, the court must consider whether or not they would endanger the safety of the public or any particular person, or will commit a Schedule 1 offence. That ground in Section 60 sub 4 as read together with the factors in Section 60 sub 5 of the Criminal Procedure Act. Section 60 sub 4b, the court must consider whether there is a likelihood if the accused, he or she were released on bail, will attempt to evade his or her trial. That ground is read together with the factors in Section 60 sub 6 of the Criminal Procedure Act. Section 60 sub 4c reads that where there is a likelihood that the accused,
if he or she were released on bail, will attempt to influence or intimidate witnesses or to conceal or destroy evidence. That ground is read with Section 60 sub 7 of the Criminal Procedure Act. And Section 60 sub 4D indicates where there is a likelihood that the accused, if he or she were released on bail, will undermine or jeopardize the objectives or the proper functioning of the criminal justice system, including the bail system, that ground is read together with the factors in Section 60 sub 8. Section 60 sub 4 sub E reads, where in exceptional circumstances there is a likelihood that the release of the accused will disturb the public order or undermine the public peace or security, that is read together with Section 60 sub 8 capital A. Now, when the court deals with the interest of justice, that is what needs to be considered. As I've stated, the state in this application has vehemently opposed the applicant's release on bail, and in their opposition to same, have filed affidavits of the investigating officer. Those affidavits form part of the record. The applicant, in his application for bail, has also filed affidavits and also form part of the record. I do not intend to repeat what is contained in those affidavits, except to deal with the salient aspects of bail. I do not deal with any evidence led which is not pertinent to a bail application. The state in its opposition has raised 3 grounds upon which they rely in opposing the bail. I deal first with Section 60 sub 4B, which the state dealt with, being the accused's attempt to evade his trial. I'd indicated that that ground is read with the factors in Section 60 sub 5. The factors read as follows. In considering whether the ground in those factors fall within Section 60 sub 6. In considering whether the ground in subsection 4B has been established, the court may, where applicable, take into account the following factors, namely, the emotional, family, community, or occupational ties of the accused to the place at which he or she is to be tried, the assets held by the accused and where such assets are situated, the means and travel documents held by the accused which may enable him or her to leave the country, the extent, if any, to which the accused can afford to forfeit the amount of bail which may be set, the question whether the extradition of the accused could readily be effected should he or she flee across the borders of the Republic in an attempt to evade his trial, the nature and gravity of the charge on which the accused is to be tried, the strength of the state's case against the accused, and the incentive that he or she may in consequence have to attempt to evade his or her trial, the nature and gravity of the punishment which is likely to be imposed should the accused be convicted of the charges against him or her, the binding effect and enforceability of the bail conditions which may be imposed and the ease with which such conditions could be breached, or any other factor which in the opinion of the court should be taken into account. The state in its application has led the evidence that the applicant was aware that there was a warrant of arrest which had been obtained in order that his arrest may be effected. He then engaged in what can be termed a cat and mouse game of catch me if you can. He did so by moving between the addresses. In the case of State versus Umpalumpa, 2007, Volume 2, SACR at 133, specifically at page 136, paragraphs F to L, the learned judge stated, and I open quotation, "It is indeed so that the appellant's decision to hand himself over to the police at the end of January 2005, after discussing the matter with his father, is indicative of his willingness to stand trial. But it is also so that he waited a period of 2 months before doing so. The police had been looking for him at his home, where he resided with his parents, since the beginning of November 2024. They had called there at various times during the day and night without success. The conclusion is difficult to avoid that he had been deliberately avoiding the police for a considerable time, and that his father had not been able to persuade him to give himself up earlier. This, in my view, reduces considerably one's confidence that he will ultimately stand trial. He knows that he has made confessions, and by now he must know that one or more of his co-accused have implicated him in their statements to the police. He knows that he faces a lengthy term of imprisonment, and in terms of the legislation prescribing the minimum sentences if he is convicted. He will not put up his bail money himself. It will have to be paid by his father. In light of these considerations, the fact that he decides to give himself up to the police after a discussion with his father is not in itself sufficient to amount to exceptional circumstances, which on its own warrants his release on bail. Now, I mention this case because the evidence before me on the part of the state is that the applicant had done much in his power to avoid being arrested. He had employed various tactics, and his tactics, according to the state, is an indication that he was avoiding being arrested and avoiding having to stand trial. However, I must add that this case is distinguishable in certain aspects regarding the present matter. In the case of State versus Hudson, a Durban and Coast Local Division decision, the learned judge at page 133 stated, open quotes, "When accused applies for bail and confirms on oath that he has no intention of absconding, due weight, of course, has to be given to the statement on oath. However, since an accused who does have such an intention is hardly likely to admit it, implicit reliance cannot be placed on the mere say-so of the accused. The court should examine the circumstances." Yes, it is apparent that the applicant, being aware of the J50 warrant of arrest, employed rather unfavorable tactics which ultimately have culminated in the state now choosing to oppose his release on bail. The ultimate question is, will the accused evade his trial? Obviously, the defense argues differently, and their version of what had transpired from the 2nd of May until the 6th of May is that the applicant was trying to establish whether or not there was a valid warrant of arrest for him, and that is the reason he employed those tactics. The state has gone into great detail by showing the video clips of what the applicant had done, which according to the state is indicative of him not wanting to be arrested and to avoid having to stand trial. The applicant, in his affidavit, has professed his willingness to stand trial. Can this court ignore the fact that he has a fixed address and at times he resides at his parliamentary address? From the applicant's affidavit, he appears to have strong family ties in the Western Cape, particularly in Cape Town. He has minor children, he has an elderly mother, he has a wife, he has commitments. His family is dependent on his salary, which he receives from being a member of Parliament. It has been submitted by the state once again that his employment could at any time be terminated. As things stand, the applicant is still employed. I have not been advised otherwise. Now, as I mentioned, that much has been said about the timeline from the 2nd of May till the 6th of May. Those factors cannot be ignored, but cannot be considered in isolation as well. A further ground on which the state relies is section 60 sub 4C, which is read together with the factors in section 60 sub 7. Excuse me. The court must take into account the fact that the accused is familiar with the identity of the witnesses and the evidence which they may bring against him or her, whether the witnesses have already made statements and agreed to testify, whether the investigation against the accused has already been completed, the relationship of the accused with the various witnesses, and the extent to which they could be influenced or intimidated, how effective and enforceable bail conditions prohibiting communication between the accused and the witnesses are likely to be, whether the accused has access to evidentiary material which is to be presented as his or her trial, the ease with which evidentiary material could be concealed or destroyed, and any other factor which in the opinion of the court should be taken into account. In this regard, the state has adduced the evidence referred to as SM Email 6, being the affidavit of a witness with whom the applicant made contact with, firstly on the 3rd of May 2026. The state further contends that the applicant had made contact with this witness up until the 5th of May 2026, when eventually this witness responded and advised the applicant to hand himself over. Now today I was informed in the closing address by the defense that the applicant, in his endeavor to bolster his court case, had made contact with that witness. He was in no way interfering with the witness, and his contact with that witness ceased after the witness advised him to hand himself over. The state contends that the applicant should have known that that was a state witness and should not have interfered with the witness. Now, in that regard, what I need to consider in dealing with bail is whether or not you have the means to interfere with witnesses and to what extent. It is apparent that you are aware of the identity of that witness. It is not disputed. You also have the ability to gain, or rather the ability to access that witness. What is apparent from that email or that document, the statement obtained from that witness, is that that witness is a member of the South African Police Services, and that you are aware of his identity. You are probably aware, Mr. Adams, of where you could get hold of him. However, that witness, being a policeman, has certain safeguards which he can rely on. In the case of State versus Branco, 2002, the court had indicated that rather than refusing bail in certain circumstances, the court should rather consider suitable bail conditions in an attempt to safeguard the safety of the witnesses. It has also become apparent with all the evidence led that there is going to be other witnesses which the state will rely on. From what I am able to ascertain from the evidence, I do believe that those witnesses are in the employ of the state, whether it be with the Department of Correctional Services, whether it be the Durban Metro Police, or members of the political task team. A further factor that the court must consider, and looking at what the state has given, is what they rely on, being the fact that the applicant has no regard for the law, and that in dealing with this, the court must consider to what extent the applicant would undermine or jeopardize the objectives or the proper functioning of the criminal justice system, including the bail system. The state's contention or argument lies with the fact that previously the applicant did not comply with a court order of the Equality Court. The state's version is that the applicant was taken back to court on a charge of criminal injuria, and as a result of the state's intervention, the charge was eventually withdrawn. The defense has presented a different version. I, unfortunately, was not there. I don't know exactly what had happened. I've not been placed with the record of those proceedings. I cannot make an informed decision without the necessary evidence. What I can say however, in respect of that, is that when our citizens of this country choose to undermine or jeopardize our criminal justice system, then the courts need to take an informed approach and deal accordingly. What is clear when dealing with Section 60 sub 4D, and in summarizing that evidence, the applicant, and as was submitted by his counsel, chooses to play by his own rules. His contemptuous behavior or attitude cannot be ignored. However, what this court must be mindful of is the ultimate fact that the state does have recourse in this regard. There are methods and ways in which the state can deal with this contemptuous behavior. In the case of State versus Skittercut and others, which as a result of that case, the State versus Dlamini judgment emanated, the court held in State versus Skittercut, 1998, Volume 2 SACR, a Cape Provincial Division decision. The learned acting judge stated as follows: bail proceedings are sui generis. The state is thus not obliged in its turn to produce evidence in the true sense. It is not bound by the same formality. The court may take account of whatever information is placed before it in order to form what is essentially an opinion or a value judgment of what an uncertain future holds. The court must prognosticate. To do this, it must necessarily have regard to whatever is put up by the state in order to decide whether the accused has discharged the onus. In the case of State versus Portham, which was mentioned by the defense, the court held that where a bail applicant was not a flight risk, nor there was any evidence that he was likely to interfere with the state witnesses and or investigation, he had discharged the burden of proof which rested upon him. It is noteworthy to mention that that bail application was a Schedule 6 bail application where the onus lies with the applicant. In this case, it's a Schedule 1 bail application. The onus lies with the state. And the authorities, when I say authorities, I refer to the judgments of the higher courts and the legislation, all indicate that where an accused is likely to evade his trial, that likelihood must be more than something being a mere temptation. Now we can look at the actions of Mr. Adams prior to his arrest. The evidence is that during early April he had made contact with certain individuals in the South African police services via his attorneys inquiring about a warrant of arrest. He had received correspondence. There was no warrant of arrest. Later in May, He's then informed that there is a warrant of arrest. The state alleges that his actions after becoming aware of the warrant of arrest was catch me if you can. And yes, the video clips played do indicate that prior to the 4th of May, Mr. Adams was aware that there was a warrant of arrest out for him. His contention, of course, is that he was not aware that it was a legitimate warrant, and he wanted to test the veracity of that warrant. What is clear in summarizing all the evidence and in deciding whether or not you, Mr. Adams, are a flight risk, whether or not you would evade your trial, I have to consider your personal circumstances and weigh that against the interest of justice. As I have said, your evidence indicates that you are a family man, you have ties to South Africa, you have means to travel to your place of trial should this matter proceed to trial. You also, at this point in time, hold a position in Parliament, and that cannot be ignored. This court is fully cognizant of the Constitution of South Africa, which provides that no person ought to be deprived of his liberty and freedom arbitrarily, and if it is in the interest of justice to do so, an arrested person is entitled to be released from detention on bail. Ultimately, when considering bail, the overall question to be adjudicated upon is whether or not the applicant would stand trial. In considering the evidence placed before me, I am then satisfied that you are a suitable candidate to be released on bail. Can we agree a date for the next appearance?
We've already mentioned that, Worship. The
No.
14th of August. Can I advise the Worship why this date?
Okay.
In view of to avoid numerous travels in between.
All right.
We gave it a longer period to finalize everything so that they only comes once and then we can maybe set a trial date or transfer
No
it.
problem. Right then, Mr. Adams, you may stand. You are granted bail in the sum of 10,000 Rand cash. Your matter is remanded to the 14th of August 2026, and thereafter on such dates, times and place to which these proceedings are remanded until a verdict is given. You are not to communicate with witnesses for the prosecution, namely members of the South African Police Services, whether it be the political task team members or other members, the members of the Durban Metro Police Services, employees of the Department of Correctional Services, and as I've indicated, the members of the PKTT unit. You are to report in person to the charge office at Mitchell's Plain Police Station between the hours of 6 o'clock in the morning and 8 o'clock in the evening on Tuesdays and Saturdays, pending the finalization of this matter. You are to reside at 24 Wembley Drive, London Village, Mitchell's Plain, Cape Town. Alternatively, Unit 23, Buck Road, Pelican Park, Cape Town. And should you change any of the above-mentioned addresses, you are to notify the investigating officer of such change prior to you changing the addresses. In the event of you having to travel outside the city of Cape Town, you are to advise the investigating officer of your travel prior to undertaking any such journey, except for your purposes of travel to attend at this court. Should you be required to travel in respect of your employment commitments, you are to furnish the investigating officer with the necessary authority from your committee and obtain the investigating officer's consent thereto. When you pay your bail, you'll be furnished with a form which contains your bail conditions. Should you not adhere to these bail conditions, a warrant of arrest will be authorized for you. You will then be brought back to court. Your bail will be estreated and you will be kept in custody. Should you not attend court on the 14th of August or any subsequent date that you are advised to appear thereafter, once again, a bench warrant will be authorized for you. When that warrant is executed, you will be kept in custody. And lastly, I implore you to please respect the criminal justice system as the criminal justice system has respected you. Thank you. We stand adjourned.
Thank you, Your Honor.
All right.
Is that the roll? Do you have something else?